and friends of all the ICJ as well as every participant and speakers and organizers to today's webinar on the Global AO Festival, ICJAO, and the road to a just energy transition. First off, I'd like to thank our community partners first for your meaningful contributions to this event, also to the YCJ organizers and to all the participants attending today and for our speakers as well. So I would like to start by introducing what the ICJ Advisory Opinion on Climate Change is all about. So on the 23 July 2025, the ICJ delivered its advisory opinion on the obligations of states in respect of climate change, which inspired our current webinar today. Also, I'm Anna here, and I'm currently new to ICJ. I represent the Indonesia front, and as the researcher in human rights law, this is definitely something that I've taken a great interest in. So yes, essentially, the opinion responds to two fundamental questions: what international law requires states to do to protect the climate system, and what legal consequences may arise when states fail to meet these obligations and contribute to significant climate harm. The court makes it clear that climate action is no longer a simple matter of a voluntary commitment or political declaration. States have legal obligations arising from the Paris Agreement, customary international law, international human rights law, the law of the sea, and even environmental treaties. These obligations include preparing increasingly ambitious, nationally determined contributions, or you might have heard the term NDCs being thrown around, pursuing effective domestic mitigation and adaptation strategies, preventing significant environmental transboundary harm, regulating the conduct of private actors linked to climate change itself, and cooperating through climate finance, technology transfer, and capacity building. The opinion also reinforces the relationship between climate change and human rights, as climate change, as it turns out, affects the enjoyment of rights to life, health, food, water, and particularly the clean, healthy, and sustainable environment. At the same time, the policies in response to climate change must themselves respect human rights and avoid placing disproportionate burdens on workers, indigenous peoples, local communities, and other affected vulnerable groups. This is particularly relevant in Asia, in which we have this variety of economic capacities, energy systems, development priorities, and vulnerability to climate impacts. Many Asian countries must rapidly reduce emissions, while in the same time, they would have to address energy access, economic development, employment, and the currently ongoing dependence on fossil fuel industries. But still, the advisory opinion provided an important legal foundation for discussing what also we know as just transition. What just transition is, we'll unpack it here. And yes, just a bit of a spoiler alert, transition itself must be defined as a process of equitable, participatory, rights respecting, and supported by adequate finance, technology, and international cooperation. Against this background, today's discussion on the anniversary of the ICJ Advisory Opinion on Climate Change will explore what this opinion means for a just transition across Asia, including how it may reshape state responsibility, strengthen accountability for fossil fuel expansion, support demands for climate finance adaptation, and help translate just transition commitments into practical, equitable, and rights-respecting policies. With that, I'm handing the floor to Prajwal, the Asian Front convener of the YCJ, to deliver his opening remark.
Thank you so much, Anna. Hello, everyone. Thank you for joining. I can see many friends are still joining. First of all, just introducing myself, I'm Prajwal from Nepal. I am the Asian Front convener of World's Youth for Climate Justice. I would like to I would like to welcome all of you to the first. So we have a series of session today after Pacific. This is the second one, the Asian one. So I would like to welcome all of you to the Asian Front webinar organized by World's Youth for Climate Justice, along with our partner organizations. We have many partner organizations who have supported us throughout this process. If I take name, maybe I'll miss some of them. So that's why I will not take their names specifically, but there are so many of them who not only supported us in promoting the event, but also designing the posters and finding speakers and in many ways. So I would like to specially thank all the partner organizations who supported us in organizing this webinar. Along with that, I would like to welcome our panelists who are already here. Thank you so much for giving your time. Um, I know all of you are very busy, but still you manage your time to be here. So all of you know today was the day when International Court of Justice gave the advisory opinion on climate change. We are celebrating the 1 year anniversary of ICJAO. But along with that, we also need to realize how difficult we are having in implementing the ICJAO. The campaign, I hope all of you know how it was started, but we after the ICJU delivered, we didn't stop. Our organization, along with Pacific Island students fighting climate change, we continue to work on implementation of the advisory opinion as well. So that's why we are still working on it. It was not an easy task. There have been some good examples of implementation. Some of the courts have already recognized and used ICJ advisory opinion in their decisions. Some states have already mentioned and used ICJ advisory opinion in their NDCs, in their national policies. That is what we want, and we are working still. That's why, just for an information, World's Youth for Climate Justice is also going to launch very soon a global campaign on implementation of ICJ advisory opinion. We are still in the planning phase, but we are going to launch this campaign very soon. And with this, I would not take a lot of your time. Thank you so much to all the attendees as well. We have good number of attendees. Thank you so much for joining, and I hope you will learn a lot from this session. Thank you, Anna. You can take it forward. Thank you.
Thank you, Prajwal. Very exciting campaign upcoming there. Couldn't wait for the progress. Okay, perhaps we can start the session now. Um, I'd like to ask the first one to be Matthew. Okay, hi Matthew, are you here with us?
Hi, Anna.
Hi. Okay, how are you?
Very good. Yeah, happy birthday, happy anniversary, as we should be talking about.
Yeah, it is a nice reminder that states indeed now have the fundamental, the policy, well, another reference to benchmark what just transition really means. And yes, while it does confirm that states have legal obligations based on this advisory opinion to prevent significant climate harm. However, from an international environmental law perspective, well, I am aware that there is quite an alarming amount of views that tend to differentiate between international environmental law and international climate change law. And how does this reshape the legal understanding then of a just transition, particularly for Asian states that continue to rely heavily on the fossil fuels?
Yeah, so I mean, I think that's a really good question. And I mean, we know that it's a year since the judgment. I think many people are still trying to come to terms with it. I mean, I've spoken a lot on the ICJ advisory opinion at a number of forums. And the first thing is still people say, well, it's an advisory opinion. And I say, well, that's not true. It's not an advisory opinion, except that it wasn't a final judgment between the parties, but it was a restatement of the clear, overwhelming law about obligations of states. And it reiterated in particular the states have an obligation not to cause harm. Climate change is catastrophic and quite singular event because it is happening globally. and therefore individual states all bear an individual and group responsibility. And I think this is where, from our perspective, that duty of the states not to cause harm has changed a lot of the discussion about the responsibility of states. I think in ASEAN, we've often relied on sort of common but differentiated responsibility. And I think the court has said, well, we're going a bit beyond that now. We're looking that states have this duty not to cause harm, and climate change is caused by the emission of greenhouse gases. And as a result, in context, we have to ensure that every state has to take action now to reduce their emissions. The ICJ also made it quite clear that that obligation of states for the due diligence aspects must be stringent. So the International Court of Justice, the advisory opinion, also elevated environmental impact assessment, I think, to a norm of international law. Previously, transboundary EIA was clearly a norm, but there was some argument as to whether environmental impact assessment was a norm. I think the ICJ made it quite clear that environmental impact assessment was a norm. And so therefore, when you're looking at fossil fuel, any sort of energy transition project or energy project, you have to look at it in the context that relying on fossil fuels has changed over the last year. There has to be far more stringent due diligence placed on fossil fuel emissions, and that means renewables are far more attractive, or should be far more attractive, to decision makers. And that, I think, is one of the big challenges for us within Southeast Asia, that there's still this reliance on fossil fuels without taking into account that continual reliance or approving fossil fuel projects when you haven't done that stringent due diligence may lead to you as a country being liable for damages and other impacts under international law. Because that's also what the ICJ said, is that if you don't adopt your stringent due diligence, if you don't adopt policies for your energy that is focused on meeting their 1.5 degree target, which we know we're already planning to exceed, then the state, the decision maker, may be liable for that harm and that damage under international law. And I think this is very important also when we're considering the liability of companies when they're seeking approvals. And I think, very importantly, we're still grappling with how the ICJ advisory opinion and the other advisory opinions mesh with that impact assessment process. I'm also of the opinion that it also means governments, when they're imposing conditions of consent to any energy project, have to take into account their obligations under the ICJ advisory opinion. And that really means that fossil fuel projects are always going to have significant fees, significant fines, significant obligations for profits being put into accounts for loss and damages going forward, to make sure and make it quite clear that fossil fuel projects are simply uneconomic because of this clear liability that either the government or the private sector will have to bear if they go ahead with it. And I don't think we've grappled with that. And I think this is the major change where I see governments looking at the advisory opinion, looking at the obligations that the state has, that the court has made quite clear are there. And governments and companies are still trying to think that this is not really something that legally binds them, that it's more an advisory opinion. That has to change. We have to make it quite clear that these obligations are clear and they're mandatory. They're not discretionary, they're not advisory, but they're legally binding obligations that will have legal and other consequences if they're not taken into account by decision makers.
Okay, thank you very much, Matthew, for the very comprehensive answer. I like how you pointed out that there is an increasing trend on non-fossil fuel projects instead in support of these commitment, as well as the fact that, well, what the advisory opinion does, as a matter of fact, is just clarify that there are already existing obligations, that it catalogs all of these obligations, something that well, the ICJ or perhaps a body with the power to connect how international law may relate to the discussions of international environmental law and international climate law may intersect. Okay, thank you very much, Matthew. With that, I would like to ask the floor for any question, perhaps from the participant. Is there any question from the participant to Matthew? Okay. Okay, or you can also ask in the chat box. Okay, perhaps for participants who have problems with their connections or microphone, you can type it out in the chat box. I haven't seen any name here. Okay. Now, thank you very much, Matthew, for your answer. Now, let's move on to the next speaker. Next is Miss Hafiz. Mr. Hafiz. Are you here with us? Mr. Hafiz? Hafiz? Okay. Yes. Okay. Mr. Hafiz?
Yeah.
Yeah. Okay, thank you, Mr. Hafiz, for your time here. Also, how are you today?
I'm fine. How are you?
Very excited, but also quite nervous because I'm in the face of all the experts. Okay. Thank you, Mr. Harvey, for your attendance here. You as a direct practitioner in the field, I imagine that you have many exposure to how climate litigation practices are happening in your country. And I'm aware that Bangladesh, however, contributes relatively very little to global greenhouse gas emissions, yet it remains among the countries of whom have the most vulnerable risks to climate change, or we might be familiar with the term climate disaster or climate-related risk disasters that's causing things like recurring flooding to sea level rise. And I was wondering, in your perspective, then, in order to effectively address this, of course, then the question goes into just transition. And I'm curious to learn what kind of just transition would look like for climate vulnerable developing countries whose priority is expanding energy access while adapting to the escalating climate impacts.
Okay, thank you so much. Hello everyone who are watching me or listening me. So it's my great privilege and honor to join this webinar because it's the first anniversary of the advisory opinion of the International Court of Justice. And you see the topic is very interesting, how the opinion can really facilitate towards the just energy transition. So, my colleagues, just transition even particularly focus on the energy transition, but particularly the negotiators from developing countries like me. I'm lead negotiator for loss and damage for 44 least developing countries. So our concern is that just transition, just not only the energy transition, that includes also addressing loss and damage and adaptation. So always we would like to focus the broader context of the climate justice, just transition. So at the international level, colleagues, after this advisory opinion, we, the developing country negotiators, really wanted to see the reference of this advisory opinion in the cover decision from the COP30. At the same time, we loss and damage negotiators, we also wanted specific reference to the loss and damage decision. But unfortunately, it's triple C process is consensus based. So, sorry, so it was not possible to see the reference of advisory opinion into the last COP30 decisions. But we tried still. We will continue our efforts in the next COP. So, because it gives us a clear judicial, I would say judicial legal interpretation particularly if you focus on the Article 8 of the Paris Agreement with the specific footnote that is exclusionary footnote 152 that stated Article 8 does not provide the basis for liability and compensation. But that was really confusing for all the negotiators, different stakeholders all over the world. But now it's clear. Even Article 8 of the Paris Agreement is qualified by a footnote, but international law, customary international law, clearly recognized that for loss and damage, there is a state obligation and it must be compensated with satisfaction. So these are the international context. Now come back to the national context. You talked about the vulnerabilities of Bangladesh, right? Let me now relate with the ICJAO with the just transition processes. Back home, we do appreciate the World Youth Forum. You guys are continue the campaign for implementation of the this advisory opinion, and we got the resolution. Now, how to implement at the national level? For example, just transition, all the issues that we can promote at the national level, utilizing the advisory opinion from the ICJ. But how it is? Actually, the Center for Climate Justice, in collaboration with Bangladesh government, soon after the judgment last year, September, we organized a workshop with inviting all the relevant stakeholders, government, non-governmental organization, academics, civil society, youth. So what we wanted to do, actually, we wanted to make aware all stakeholders about the judgment and what was that judgment and what does it mean for the national level, what is the implications. So stakeholder awareness was our starting point back home. And secondly, if you look at the very interestingly, our third NDC, Bangladesh already communicated to UNFCCC. In the loss and damage chapter, we referred the ICJ advisory opinion. I think this is a very interesting and important recognition because in DC we communicated our needs for mitigation, adaptation, also loss and damage, but at the same time we reminded the global community that at the national level we are considering the ICJ advisory opinion seriously and we would like to implement. Now, to advance, particularly the just transition, since I said we would like to focus on adaptation and loss and damage rather than mitigation, because you said Bangladesh contributed a very little greenhouse gas emission. So we don't have responsibility for the mitigation at all. But just transition, what you said, we can facilitate energy transition through providing access to energy by the vulnerable communities. That also can reduce the vulnerabilities of the community. Let me explain it a little bit. If we can ensure the access to justice, access to clean justice to the vulnerable communities, and if they can access the energy, they can produce more food, right? Like irrigation. So that access to justice can provide you food security, and that can build up your resilience, and that can reduce your vulnerabilities. This is how energy transition, access to clean energy, can facilitate really just transition in vulnerable countries like Bangladesh. Second is that since we are thinking adaptation, also loss and damage migration is the classical example of loss and damage. Colleague, you need to face a little bit background noise because it's Azan time here in Bangladesh. So, can you close the? So, yeah, I'm sorry for that. So I was talking also about the displacement. Look, if in terms of displacement, we need to ensure the just transition to facilitate their rehabilitation, right? For example, a fisher folk is displacing from the coastal zone and going to the hill areas. He or she needs to adjust with the new livelihoods. So livelihoods rehabilitation is one of the most big challenges. Also, rehabilitate the culture, food, tradition, all these societies. So how ICJ advisory opinion can really facilitate for just transition, not only for the energy transition, but also how to transit communities from the vulnerabilities to resilience. Let me repeat. We need to
Okay.
facilitate vulnerable communities so that they can reduce their vulnerability and transit their livelihood. This is how we are thinking. So maybe, yeah,
Okay.
I'll stop here.
Okay, thank you very much, Mr. Hafiz. Very inspiring insights there. The how just transition expands to L&D and also your processes on the how this could be further propelled in the next COP31 agenda. Okay, I think there are two questions already in the chat box, or perhaps we could also allocate the time for the participant who asked the question to speak, or should it be represented by me? Committee? Can we allocate the time for the okay, if not, I could ask directly if there's a time constraint. Okay, I think the first question comes from Alan Ware. Is there a possibility that a further follow-up contentious case might be taken in the ICJ by a group of most impacted countries against high greenhouse gas emitters who have not reduced their GHG emissions sufficiently to meet obligations affirmed in the advisory opinion? I think this would be something of your interest as well, Mr. Hafiz, as the next COP31 is just a few months ahead. And I reckon that will be actions taken by the ICJ as well to affirm their commitments to climate change. Feel free to answer. My apologies, you're still muted.
I'm sorry. So it's a very interesting question. You see, if we think of an implication of ICJ advisory opinion, at the same time, there are so many lawyers are now involved with litigation process in different judicial forums, right? Bangladesh Center for Climate Justice, we are also thinking to file a case in developed countries against any of the corporation on behalf of a vulnerable community or vulnerable poor farmer. So we are exploring the ways how to file this case. I think this not only me, there are many legal communities are trying to make compel the private sector, the corporations. But if you look at the ICJ advisory opinion, that made state responsible to regulate the private sector. At the same time, it gives us some authorities to file litigation into different judicial forum to compel the polluters to pay. So not only at the global level, also we can think about to compel our private sector or corporation at the national level. For example, pollution tax, green tax, climate tax, those can be some of the policy avenues that we can compel the private sector back home. At the same time, how to compel the global level, and maybe COP31 can be an opportunity. We can bring this issue, how to get some decision from the United Nations processes. I think I responded. I tried at least. Yeah.
Okay, thank you very much for the very comprehensive yet concise answer. I hope that answers the question from Alan Ware. Thank you, Mr. Hafiz. Now moving on to the next speaker, Professor Jisan Asuka. You may have the floor. Okay.
Yes, thank you very much. Happy anniversary. And I'm also happy to, as you know, the president of ICJ happened to be Japanese. So yeah, that's another reason I'm very happy. Good evening, everyone. Thank you very much for inviting me to this event. My name is Jusen Asuka. I'm a professor at Tohoku University in Sendai in Japan, which is a big emitter and very, very responsible for climate change, ongoing emission and historical emission as well. I've been working on energy and climate policy and climate energy economics. So I'm neither a lawyer or legal expert, but I was a plaintiff in Japan's first coal-fired power plant injunction lawsuit at Sendai Prefecture 10 years ago before ICJAO, and contributed significantly to the drafting of the complaint. So I do today to introduce the current situation of Japan, and I hope my talk will be useful for your activity to maybe to take some legal action to Japanese government as well. First of all, as for moderator's question, I have
Yeah, that's okay. We could
could you say something about the question?
Okay, so yes, the first question, yes, as you described before, Japan has made significant achievements in renewable energy and decarbonization technologies. All of them are actually part of the climate action. However, it continues to face challenges related to energy security, industrial competitiveness, and fossil fuel dependence. I think this relates more about while the ICJ advisory opinion enshrines the list of the laws or the rights that we have to adhere to when it concerns climate change. This question is more about how realistic would that achievement will be. So I would love to learn from your perspective, what are the most difficult trade-offs in achieving a genuinely just transition?
Okay, thank you very much. First of all, as for Miguel's question, I have to say that your idea that Japan has invested heavily in renewables is kind of big misunderstanding. I want to share one PowerPoint graph now. Can you see?
Yes.
Okay. Yes, this graph shows, just a moment. This graph shows the share of renewable electricity in major countries in 1990 and in 2023. As the graph clearly shows, Japan used to have one of the highest share of renewables, 24% in 1990. But over the following 33 years, it simply failed to make the effort to build more, to introduce more renewable energy. So okay. In 1990, it's 12%, but in 2023, it's just 24%. But compared to other countries like Norway, Denmark, Australia, Germany, Spain, Finland, it's lagging very much behind those countries. Okay, so why do people have the image that Japan invests a lot in renewables? I think two facts lie behind it. First, Japan's share really was large in the past. And second, Japanese companies used to be the front runners in solar panel manufacturing. Unfortunately, both of these are stories from the past. They are no longer true today. Now the moderator question asks, what are the most difficult trade-offs in achieving a genuinely just transition? I think it's the same for both developed countries and developed countries. And my answer about Japan is this: the biggest obstacle is not really a trade-off, but it's a blocking factor, and that is vested interest. In Japan, in particular, the liberalization of the electricity system is still incomplete, and the market remains an oligopoly of the major utility companies. Their assets are nuclear plant and fossil fuel power station. So for them, renewables and energy efficiency are the enemy. Their political influence is enormous, and sadly, very few politicians at the national level are willing to say, let's push the energy transition and let's move away from nuclear and fossil fuels. Because anyone who says something like that, they lose the election. They lose the seat. On nuclear power, there is also political motive at work, the desire to maintain the potential to produce nuclear weapons. So if you invest a lot of money to nuclear power, you invest less to renewable energy. That is happening in Japan. Given this situation, I place my hopes on the ICJ advisory opinion as a last resort, so to speak. In Japan, 2 climate lawsuits are now underway, and in both cases, the plaintiffs are drawing a lot heavily on the advisory opinion. Yeah, that is about Japan.
Okay, thank you very much, Professor, for a very elaborative answer. I was actually quite surprised that you mentioned that Japan actually experienced downfall in renewable energy investment because, as far as I was concerned, and I have been involved in several green hydrogen initiatives in Indonesia, Japan has the most advanced one. That was my understanding. So.
That is called greenwash.
Oh, greenwash. Yeah, very, very interesting to learn that. Thank you for sharing this. Oh, yeah, because we kind of like having this brain
And
fog about about it.
also waste of money.
Oh.
Yeah.
Waste of money. Yeah, yeah, but hopefully, Japan government can move toward to the better. Yeah. Okay. Perhaps is there any question from the participant to Professor Juice and Asuka? Before moving on to the next speaker. Okay, or perhaps it's all right if you want to put it in the chat box and we can compile it by the end of the session. Okay, seeing none, let's move on to the next speaker, Miss Avril. Are you here with us?
Hi, Anna. Good evening.
Hi. Yeah, good evening as well. Very excited to meet you. Also, how are you, Avril?
I'm doing well. Also very happy to join you and our other speakers and attendees tonight to celebrate the ICJ ruling and to discuss how we can maximize it.
Okay, fantastic. Okay. I think we can start with your first question, unless there is a participant here who wants to ask Avril directly before I start with the question. Hmm. Okay. I don't think we have any question yet, but I would encourage all participants to type in the chat boxes or the Q&A section if you have any questions to our speaker. And don't forget to address which speaker that you'd like to have your questions directed to. Okay, so Avril, I saw that you were the Deputy Executive Director of the Center for Energy, Ecology and Development. You're also an attorney, a climate attorney. That's a very, very impressive achievement. And that is why I think you have a very, well, good exposure when it comes to the term of a just transition. You're from Philippines, if I'm correct, or correct me if I'm wrong, but you're from Philippines, right? Okay.
Mhm.
Yeah, so I'm curious to learn, how does the ICJ advisory opinion in that sense could provide greater clarity on states' obligations, perhaps reflecting on your experience in Philippines when it comes to addressing climate change. From the perspective of civil society and your experience, perhaps you've also been in collaboration with several civil societies or organizations or networks of whom also move in this part. And how can then these particular legal development, this fundamental, very, very fundamental legal development in terms of climate change can be used to encourage more effective and equitable energy governance?
Thank you for that question, Anna. My organization, CIEL, does not only work on issues of climate and energy in the Philippines, but in fact in the larger Southeast Asia region. So I do want to provide a little bit of context in our region before explaining what the why the ICJ ruling arrived at such a critical moment for our region. I do have a few slides to set the context. Let me share that firstly. Am I allowed to share my screen?
I think the committee should give you the permission to do so. Nishal, have you given Afril the permission to share screen? I think you could do it through the share option, but will it be the committee who will be presenting, or would be from yourself?
Oh, there, I found the share button.
Oh, okay, fantastic.
Great. Sorry, I hope you can see my, sorry, hold on. Can you see my slides? There.
Yes, yes, we can see your slide.
Right. So for a long time, Southeast Asia was known as coal's last bastion. While many parts of the world were retiring coal plants, our region continued to see new coal projects being proposed. But at the turn of the decade, instead of phasing out fossil fuels and moving rapidly toward renewable energy, Southeast Asian governments are promoting gas as the answer to energy security and as a so-called transition fuel toward renewable energy. So as you can see, just to make sure you can see the slide on Southeast Asia confronted with gas and LNG. I suppose you see it.
Yes,
Yes.
we can see
So-
your slide. Yeah, we can see it.
Great. So there are massive plans for gas and LNG power plants in Southeast Asia. Over 100 gigawatts of new gas-fired power plants and more than 100 LNG terminals proposed are already under development. And unfortunately, there are even more plans for oil and gas exploration and production. Many of these oil and gas blocks overlap with protected areas in our region, as you can see in this next slide. This is something that is especially alarming because our region is a global hotspot of marine biodiversity and also a major coral reef zone. We host the Mekong Delta, the Coral Triangle, the Verde Island Passage. And so Southeast Asia is now becoming a major fossil gas and LNG hub where these fuels do not serve to help the transition, but rather detour our transition to renewable energy. For my last slide, setting the context, I also want to highlight how this is deeply concerning because Southeast Asia is also one of the most climate vulnerable regions in the world. We're faced with stronger typhoons, longer droughts, rising seas, damaged coral reefs, you name it. And so at this same period, we're also facing an energy crisis that again highlights that fossil fuels aren't delivering the energy security that governments promised. And our communities are reeling from the impacts of spiking global oil and gas prices. And in the Philippines, in my own country, a recent study said that there could be up to 3 million Filipinos that will be pushed into poverty because of the energy crisis and because of how much we rely on fossil fuels. I'll end sharing my slides there and now jump to what makes the ICJ ruling and defining governance in the Philippines and our just transition. The challenge in Southeast Asia now isn't simply the impacts of the climate crisis, but it's that we're still expanding the very industries that are making the crisis worse. This is why we think the ICJ ruling can be a game changer, because for years, communities and civil society have argued that our governments can't claim to be serious about climate justice if we ourselves continue to approve new fossil fuel projects in our own lands and in our own shores. The ICJ ruling gives that argument a much stronger legal foundation. The court said that a state's failure to protect the climate system, and that includes not only fossil fuel consumption, but also production, granting fossil fuel exploration licenses, even providing fossil fuel subsidies, these may constitute an internationally wrongful act. For us, that's powerful and clear language. Very often, especially in low and middle income countries or emerging economies like ours, we hear our own governments justifying new fossil fuel projects by saying, we're still developing, we don't really emit a lot of GHG compared to other nations. While this is true, it's also interesting that the court doesn't really carve out a distinction when discussing internationally wrongful conduct. What the court nuances is the expected standard of ambition and effort regarding climate mitigation. And that's based on a country's capabilities and developmental levels. So this is important for our engagements with our own governments. Our communities opposing coal and gas projects can now also point to an authoritative statement from the world's highest court that continued fossil fuel expansion may place states in breach of international law. Secondly, I also want to highlight how the ruling also strengthens another conversation that is especially important for us, and that's climate finance. Many of our governments also do not have the resources to transition away from fossil fuels in the speed and scale that is needed to meet 1.5. And the court reminds us that developed countries and historical emitters have legally binding obligations to provide financial resources for mitigation and also adaptation. So climate finance is recognized as part of that legal framework for achieving a just transition. I think that's important because if we're asking emerging economies to leapfrog fossil fuels or so-called transition fuels like gas and LNG, then the support to make that possible has to also follow. So for me, to conclude, I think the biggest contribution of the ruling is that it gives communities another tool, not the only tool, but an incredibly important one, to demand our own governments to stop approving and supporting new fossil fuel projects in our own lands and our own shores, and instead invest in the renewable energy future that our region desperately needs, especially during this time of crisis.
Okay, thank you, Avril. I heard very, very exciting things actually. Maybe not in the positive sense, yeah. Maybe in the sense of okay, so this is what's currently happening in Southeast Asia, in which we are forced to reckon with the fact that as emerging economies, we have the most burden to mitigate and adapt to the current impacts of the climate change. And yes, realistically speaking, support needs to follow, as well as flexible climate financing. Okay, I think thank you very much for the very insightful answer. I hope that you can continue to inspire how we can move forward to this climate crisis. And I do hope that government will be open to ideas and the political desire now also desires for something more sustainable in the longer term. Thank you, Avril.
Thank you,
Okay.
Anna.
Yeah. Now moving on to the next speaker, Miss Shreya.
Hi, Liliana.
Okay. Hello, Shreya. How are you?
I'm doing great. Thank you for asking.
Yeah. Okay. Thank you very much for attending today discussion. So as a policy advisor at the Clean Energy Netpool, I imagine that you do have some direct exposure, or perhaps since we operate in the same basis, yeah, researcher and advising, consulting essentially. I imagine that you have a very wealthy amount of knowledge to share today in regards to how Nepal's transition works. So I'm curious to learn about the priorities and challenges surrounding energy transition, especially in Nepal, considering that it is a varying processes across Asia. And from Nepal's perspective, and also take into account your experience as well, what does the just transition look like, and what factors should policymakers prioritize when it comes to pursuing it?
Yeah, thank you so much, Liliana. I do hope my internet doesn't betray me, but in that case, please let me know. I can turn off my video and see if that helps. Hi, everybody. First of all, congratulations to all of us. I think in a time when the impacts of climate change are only worsening each passing day, and when there is little accountability on how we can hold our leaders responsible, I think the way on how the International Court of Justice advisory opinion has been delivered, it does provide hope that yes, maybe tomorrow would be different. Tomorrow would be able to hold our leaders responsible for what they have committed and to ensure that they deliver. And to your question, April, I think that's an important question. Normally, when we talk about just transition, we can see that it is often framed as helping workers, right, transitioning or giving them opportunities to move away from fossil fuel industries, or redirecting fossil fuel subsidies to clean energy and so on, which is also important because it has to reflect the realities of industrialized countries. But I do see that this form of framing, which we often see in the discussions on how just transition is only being embedded to the energy sector, it does not capture fully the context of many countries like Nepal and many other developing countries. And I think when we do this, we risk overlooking the deeper structural inequalities that has been in the place for so long. In Nepal's case, it is no exception. As a least developed, landlocked country, I think Hafiz was also talking about how LDCs, least developed countries, are working to ensure there's a greater accountability. And we as LDCs in Nepal, as a mountainous country where majority of our GDP is dependent on agriculture and tourism, we are highly vulnerable to climate change. And again, the communities who are most exposed, right, to floods, to landslides, or let's say heat waves, or glacial lake outburst floods in the mountains, they are often the one who has the least access to resources, who has the least access to infrastructure and finance. So, and communities, when we talk about clean energy, in Nepal, we have achieved nearly 100% electrification. We say 98, 99% in the last 50 years, which is a significant feat. But again, when we talk about communities who are living around this large hydropower project, they have often experienced land acquisition, displacement, and the degradation of their ecosystem, and the disruption of their livelihood. And when there's a private sector, or let's say some other agency who is taking the benefit from all of it, they are forced, of course, to face the most impact due to changing climate, but also to deal with the repercussions, of a development that was not done by the proper consent, proper research, and so on. I think for all of us, when we talk about just transition, it has to be a development transition, and of course, reducing emissions, going to clean energy. That is a given thing. But I think when we talk about just transition, it is also an opportunity to kind of connect the dots between the development, between climate emissions, but also between inequality, who is being left out. And I think when we talk about just transition, few of the elements that are given that has to be and that has to shape what that means actually should be one, it has to be people-centered. If there's a transition, we're talking about just, right? It's not just transition, we're talking about just transition. And for that to happen, it has to put people at the center. And when I say people, it is those who are most affected, who has been marginalized by the system. And there has to be a meaningful social dialogue to ensure that the transitioning is benefiting to everybody. And nobody is left to bear the consequences of transition, because there's some cost associated with it. Another, we have to address the global inequality and structural injustice, because there's a reason why climate change is happening. There's a reason why inequality is in place, right? So if we try to do just transition with the same structure in the place, then we'll not be able to solve the problem that we have in hand. So we have to fundamentally change, and we have to resist against the oppression systems, but also undo the harms for the communities, for the countries who has bear the consequences of it. The third, those who has been most affected, they has to receive support at the first place. And fourth would be to develop context-specific approaches. Of course, we might need a specific approach how we do transition in energy, but that would be different how we do it in forms of agriculture, right? So there has to be a context-sensitive approach, and we ensure there's no size-fits-all approach. And I think few of the factors that policymakers should consider must. One would be to treat transition as a whole of a development agenda, not just to reduce our emissions and tackle climate change, but move beyond that and see it in a holistic lens. Number two, as I was saying again, people has to be at the center. They have to define what transition means for them, rather than an external agency or partners coming and imposing their ideas on people. And third, and again, just transition, when you talk about it, of course, it is beneficial, but there's a cost associated with it. So governments, local governments, I think there's a need to study what are the implications of just transition in the first place. and then to inform our approaches accordingly. I think the fourth and most important would be to localize it. Of course, there's a federal government, but in many countries there are also local government, and who has to take the ownership, right? People has to take the ownership of transition. So when we engage local government, I think the ownership factor comes a bit faster. In case of Nepal, we're working with Itahari and Dulikhel, two of the subnational government who has adopted, or let's say who has committed to the fossil fuel treaty, committing not to introduce like new industries that runs on fossil fuel. And they have done many of the significant factors that I think would be difficult to do it on a national level. So I think localization would be another important thing. Yeah, I think that is what I think should form just transition and what factors policymakers should prioritize. Thank you so much, Liana.
Okay, thank you, Shreya. Very exciting points there. You mentioned that transition should be a developing processes, which is of course, sorry, the term just transition should be a developing process because, well, as we all know it, sometimes there will be certain developments that would implicate the rights of the peoples already impacted by certain developments, which may or may not actually intends for a greening or climate advancement. But as a matter of fact, it severely impacted them in the way that that's negatively. And you mentioned as well, there's need to be an approach that's people centered because of the issues such as land acquisition and displacements. I think, from what I gathered, the problems that we face in Southeast Asia and in Nepal in general are quite similar. Land acquisition and displacement, yeah, we have too much of that too, as a matter of fact. Okay, thank you very much, Shreya, for the very inspiring and insightful answer. Now, let's move on to the next session. Okay, first, before we go to the Q&A, I think I would like to have the questions already asked before in the chat box. First is the question for Matthew. As civil society, what do we need to do in the coming years to leverage these advisory opinions, as not all of us are legal organizations? Matthew, feel free.
Thank you. That's a really good question. I mean, for me, a lot of it is, as we've discussed, it's trying to highlight that the business as usual case has changed, and I see this a lot when talking about sustainable finance. I've seen it a lot in a number of different fora where they sort of say, well, renewables are still more expensive or there's more risk involved. But the reality is that the continuing reliance on fossil fuels, as has been pointed out, has significant consequences, and they're not even any risk anymore. We know that if you build something like promote a coal-fired power plant or LNG, you have to start to pay for the pollution, and that pollution now under the ICJ is clearly the climate risk. And so that's also the change, is that we can't just sort of Indonesia, for example, or India or Nepal or any country, Australia in particular, can't just say, well, we need this, we need to transition, we need gas as a transition fuel when we're retiring coal. It doesn't work that way anymore. The court has said, climate change is an issue now that has very, very serious and significant consequences. It's clearly caused by anthropogenic sources and by greenhouse gas emissions, and therefore any government or any private sector that's proposing to emit greenhouse gases is going to be liable for loss and damage. So in terms of what we can all do is to make it quite clear that is now, a year ago, the World's Court made it quite clear, irrespective of any of the greenwashing from the fossil fuel industry or the gas industry, that it's a transition fuel, that it's too late now. We now have to actually take significant action. Now, that means that if you're not a lawyer, you still have the opportunity of making the case in policy debates. can still be in questions of whether people become plaintiffs to argue why governments have to take action. But I think that's also where the cost of fossil fuel, and we can argue also that, well, if governments are still going to approve coal-fired power plants or coal mines or gas transition, that then it has to come with a cost, and that cost has to be borne by the proponent under the polluter pays principle. And so that means that their profits have to be put into a fund where it can pay for the damage that we know is going to be suffered by communities. And I think that's where we have to make it quite clear on every front that business as usual is not profitable, it's not appropriate. We have to then move on into not only the transition into renewables, but also energy efficiency, reducing our consumption, all of the things that are talked about, where people say, well, you just want to say no to fossil fuels. We say, well, no, we want to say no to overconsumptive energy, poor energy management, and all of those issues that are associated with fossil fuels, and including, for coal-fired power plants, air pollution, which is now a gravely significant human rights and environmental threat. So it's not just for lawyers, and I think this is also where, as we know, this entire debate was motivated by students and young people, and we should never forget that it was the youth of the Pacific joining with the youth of the world that actually forced, for the first time, the world's court to take notice of what was happening on the ground. And that's something that we can all be. We can all be advocates, whether we've got law degrees or not. Thanks, Anna.
Thank you, Matthew, for the answer. I love how you put that the ICJAO actually makes the idea of climate action to be more inclusive. So it's not just about the things that what lawyers can do or those with already the legal certifications to do, but everyone can take part in it. Okay, moving on to the next question. This is for Avril. This is a question from Alan Ware. Okay, this is a bit of a long one, but Philippines courts have led on the rights of nature and future generations, including the landmark Philippine Miners Oposa versus Facturant in 1993, which established the legal principles of intergenerational responsibilities and standing for future generations. Tony Oposa, who led the case, was also an early promoter of the ICJ advisory opinion on climate. What possibly do you think there is for Philippines and other Southeast Asia to advance this further by establishing a ombudsperson or commissioner for future generations, as Wales has done? In Wales, this has been very effective at changing policy to protect the climate for future generations. Yeah, feel free, Avril.
That's a really good question from Alan. I want to say that I think, firstly, that's how we should approach the ICJ ruling, thinking out of the box and imagining not only novel legal actions, but also policy engagements and public campaigning that we can do using the ICJ ruling. So on establishing an ombudsperson or a commissioner for future generations, as has been done in Wales, to be frank, it's something that I have not heard anyone in the climate space in the Philippines push for yet. But as you've mentioned, the legal principle of international responsibility came from a landmark Supreme Court decision in the Philippines. And other than that, on paper, we do have really good environmental laws. In fact, our renewable energy law is recognized as one of the first comprehensive laws on renewable energy in Asia. So I think when it comes to proposing something that's quite novel, that's new, and looking into intergenerational responsibility and how to continue to promote that, I think it definitely can happen, especially so if it's backed by frontline communities affected by the crisis. And of course, the larger and very vibrant climate justice movement, not only in the Philippines, but across Southeast Asia. So thank you for sharing that idea to us. It's something definitely that we'll start considering as well. So that's, I think, a very helpful question also for us who are thinking about what more can we do with the ICJAO.
Okay, thank you very much, Avril, also to Alan for I think inspiring all of us in attendance about okay, ombudsman person. I think that could be something that's implemented as well. And I'm also excited to hear that Philippines has the most comprehensive energy law in Southeast Asia. I think we could learn more about Philippines and set as our benchmark on what kind of energy law is appropriate to advance this transition. Thank you, Avril. Now moving on to the next speaker, moving on to the next question. I think this one is addressed to Professor Jusen Asuka. The question is, how can we address the newer forms of greenwashing? Professor, are you here with us? Hello, Professor Jusen, are you here with us?
Yes, I'm sorry. Could you repeat the question?
Okay. The question is, how can we address the newer forms of greenwashing?
New forms
New-
of new
Yes.
form. What kind of new forms?
I think the question is more about greenwashing has I think the understanding of greenwashing is companies hiding
Yeah.
traces and they're growing more innovative in doing
Mhm.
so. Yeah. So I think the question is addressing how then we can address this particular problem. Yeah, the innovative ways that some companies or perhaps entities try to claim that they've done their climate commitments, but in reality, they're just doing another form of greenwashing.
Yeah, I agree that greenwashing is getting very, very sophisticated and very, very easy to fooled by those kind of advertisement by the government and by the company as well. So, yeah, I don't have silver bullet to tackle this issue, but I think we should make more fact-checking about the governmental claim and also companies' claim. Especially, I'm fighting against Japanese government NDC because government is saying that Japanese NDC is consistent with 1.5 degrees. That is nonsense for me. But many people in Japan believes Japanese NDC is enough to reach the target of 1.5 degrees. So I have to explain the carbon budget and allocation equity CBDR, but still it's not so easy to convince using those kind of jargon to ordinary people in Japan. So I have to have come up with more easy way to make people understand what is CBDR, what is equity. But still I'm struggling but I just want people understand that the Japanese government keep on saying Japanese NDC is consistent with 1.5 degrees. That means Japanese NDC cannot be ratcheted up and Japanese government is doing enough to tackle climate change. So that is kind of thing I am fighting for many years. Also, I'm big fan of Future Generation Act of the Wales. So I'm promoting Future Generation Act of Wales to Japan. So I hope these two AOs, ICJAO and Future Generation Act will make some synergy in the future policy making in Japan.
Okay. Thank you, Professor. Yeah, I couldn't agree more. I think then we would have to be the ones to be able to verify it if there is a, let's say, coordination between the entities involved in the newer forms of greenwashing. As I mentioned earlier, that yeah, there needs to be a more a stricter communication between the government and as well as the entities of him involved in disclosing their, let's say, sustainability reports or climate disclosure reports. I hope that answers the question. Okay, now we're moving on to the next. Thank you, Professor Jusen. We're moving on to the next question.
Can I do just one?
Okay, sure, go ahead.
Because the logic of the argument of the Japanese government is there is no international rule for allocation of carbon budget in case of NDC decision making. But that was before ICJAO. ICJAO emphasized the CBDR or equitable allocation or historical responsibility. So that's why I think the ICJAO will have big pressure to Japan's government for ratcheting up the more ambitious target of NDC. I hope. So please hope with me. Thank you.
Yeah, let's hope for the more ambitious step. Yeah, looking onward to the next COP31 discussion as well as its side events. Thank you very much, Professor Jusen, for the very comprehensive answer. I think we could move on to the next question. This is also intended for Avril. The question is, does the developing of just transition framework in the Philippines side, or is it informed by the ICJ advisory opinion? So yeah, do you have any perhaps an insider information to share if it's already influenced by the ICJ advisory opinion on climate change, or maybe it hasn't yet to be influenced by it?
The development of the just transition framework in the Philippines started long before, over a decade ago in 2016, when we enacted the Green Jobs Act, and the Philippines became one of the pilot countries of the ILO's Just Transition program. But there is a more recent effort that's led by a different government agency, the Department of Environment and Natural Resources, and definitely in consultations or engagements with those agencies, the ICJAO ruling has been shared and cited by most especially civil society organizations to influence that framework that's being developed.
Okay, that's actually very good news to hear that it already influenced it. Okay, I hope that answers the question to Avril. Thank you very much for the answer, Avril. Now moving on to the next question. This is intended to for Shreya. The question is, I think this is more of a reflection. I would add that the narrow framing for workers in just transition can also be problematic in that it does not capture the whole of economy approach or the intersectionalities linked to worker identities that create a profound impact on workers and does not adequately reflect a strong labor rights framing. So yeah, I think this is more of a reflection. And Shreya, if you have any 2 cents to share about this reflection, feel free.
Yeah, thanks, Juliana. I did answer it in the chat in the interest of time. But yeah, totally agree. I think if we do not make it holistic, if we're only doing the just transition from one restricted lens, then that means the consequences that has to come. If the just transition is not just, there are some consequences, right? And it has to be borne again by those who are impacted, like workers, farmers, and so on. So yeah, absolutely agree with it.
Okay, thank you, Shreya, for the answer. Now, we can move on to the next question. This one is intended for Hafiz. Hafiz, are you still with us? Yes, Mr. Hafiz, are you still with us? Hello, Mr. Hafiz?
Yes.
Okay, fantastic. All right, I have a question for you. I think this might also be the last question that we'll entertain today. So the question is, how do you see domestic courts in Bangladesh using the ICJ advisory opinion in future climate litigation, and which sectors like coastal management, agriculture, or energy in Bangladesh will benefit the most from implementing the advisory opinion?
To be honest, if we look at the current state of climate litigations here in Bangladesh, is very limited. So court need to utilize the references of International Court of Justice, any judgment, so far I know. But government is taking it serious. So now government is developing some sort of policy strategies, particularly on climate change, finance related. Recently, government is thinking to develop a climate finance strategy, also some sort of institutional structure for finance. So I think during developing these sort of policy strategies, plans, what you mentioned about the coastal zone, so to develop the coastal planning or coastal strategies, we can use the not only references but also the current resolution, how to implement. So both of the resolutions are really important. So this resolution provides us some guidance how to utilize this opinion, not only global level, also at the national level. So that would be really helpful. So this is the time to be innovative for the policymakers, or not only policymakers, all the relevant stakeholders, and to promote the idea how to facilitate just transition. So I would like to request all of you here today to work with your national governments so that we can provide some input, expert understanding so that government policymakers can utilize these references. Thank you.
Okay, thank you very much, Mr. Hafiz, for a very comprehensive and wonderful elaboration. Now, I think we have reached the end of the session, but however, before we are closing this, I would like to invite the speakers to deliver one sentence about just energy transition. Yeah, just one sentence. What does it mean to you? Or what kind of what kind of sentence would represent just energy transition, sort of like the closing remark, but more more concise in just one sentence from you. Perhaps we can start from Matthew.
Thanks, Anna. For me, the just energy transmission has to be just. We have to make sure and hold governments and private sector to account, because business as usual will not save our planet. So that just transition really has to be focused on ensuring that there is a real transition and that the benefits of that transition apply across to all communities. So that's my view about just transition.
Okay, thank you, Matthew. Now, perhaps, okay, I think due to time constraints, we could have one more, perhaps, to make one sentence about just energy transition. Do we have any volunteer, perhaps, from the speaker?
May I come in?
Yeah, sure. Go ahead, Mr. Hafiz.
For me, very simple. From the vulnerable developing countries perspective, just energy transition for us is that access to clean energy and reducing vulnerability. Full stop.
That's a very wonderful statement, Mr. Hafiz. Okay. Thank you everyone for attending the session. Thank you as well to the speakers and organizers and community partners for being able to bring this wonderful event to fruition. And now I would like to invite Mitzi Salcido from the Climate Reality Project in Philippines to deliver your closing remarks. Mitzi, you may have the floor.
Thank you, Friliana. Good morning, good afternoon, and good evening to everyone, where you are right now across the globe. And I do hope I can deliver this closing message as a message of hope, and I'll try to make this quick. But before anything else, I think it is deserving to give a big round of applause to the organizers, the World's Youth for Climate Justice Asia Front, and to our partners who made this online discussion successful and a day worth celebrating. So as we bring today's discussion to close, I want to take a moment to sit with the significance of the date on which we are virtually gathered. 1 year ago today, on the 23rd of July, 2025, the International Court of Justice, the highest judicial body of the United Nations, looked at the defining crisis of our time and spoke with one voice, unanimously, on every single point. That in itself should give us a pause. In international law and even at the national or state level, unanimity is kind of rare or would take decades to campaign and succeed. But achieving consensus is also challenging. And yet, here, on a question that touches every nation, every economy, and every future generation, the world's highest court found the common ground. So we should remember, too, how this journey began, not just in a courtroom, but with a group of students, youth advocates in the Pacific, and a small island nation of Vanuatu that refused to accept that the world's most vulnerable people should simply absorb the consequences of a crisis they did list or didn't contribute. So showing this persistence carried this question all the way to the UN General Assembly, and from there to nearly 100 states and international organizations who came before the court. That's the largest participation in the history of ICJ proceedings. So that is what determined patient advocacy can achieve. So to every resource speaker who joined us today, thank you for sharpening our understanding of what this climate ruling means and where it can take us. To everyone listening, legal practitioners, scientists, advocates, students who may one day carry this work further, thank you for showing up in this discussion. Thank you for showing up for the planet and for caring enough about this issue to spend your morning, afternoon, evening here with us. Thank you all, and I think let us continue to bring this unified hope for a better reality. And again, let us give a virtual round of applause to everyone here.
Okay, thank you very much, Mitzi, for your remark. Very inspiring words to close this session.